Hey guys, okay, almost done. We just finished up that this contract could not be assigned to a third party. So right now, let's go back to the facts. In the fact pattern, I have here all notices regarding this agreement shall be in writing. Applicable governing law is that of the state of Florida. Clauses shall be severable, and no modification may be made in writing no modification may be made except in writing and executed by both parties. Okay, so we got to make sure we get all those facts in there. So let's take them one at a time. All notices regarding this agreement shall be in writing, because you guys will have already read through these contracts and this fact pattern, these sample contracts and this fact pattern. Those words should be ringing a bell to you. So you would go to the sample contracts and say, all right, which one talked about notice? Let's see here. Up, scrolling down, here it is. This sample contract talked about notice. And look at that language. All notices herein shall be in writing. And here it says, and may be delivered personally or by mail, postage prepaid. And then it has some language about postage prepaid. I did not include that in the fact pattern. So here's where you do, what's reasonable. One would be you could just include this as written. That wouldn't be wrong. But another way you could do it would be to simply say all notices herein shall be in writing and must be delivered, you could say either personally or in any reasonable manner such that the party receives actual notice, right? Based on the facts that you have, it would be very reasonable to say that, and that would be accurate, right? The whole goal is to make sure that the other party receives notice, the actual writing of whatever the other party is trying to inform them of. And that would be completely appropriate. And again, oftentimes contracts get further negotiated. So if it needs to be redrafted, you redraft it. That's what happens. But based on the information you have right now, that's what you could include. Or you could write this as written. I would be fine with that too, okay? Because it's reasonable and it's standard under the law, all right? So let's go back to our next. So we check off that fact. We got notices. Let's talk about applicable governing laws, that of the state of Florida. I think both of these contracts actually talked about that when I read through them. Applicable governing law. Here we go. A whole section on applicable law. The agreement shall be governed in all respects, including its construction and interpretation by the laws of the state of, this is the sample, right? This one says Delaware. We are going to change that to reflect our particular fact pattern and make it say Florida, right? And I think this this sample contract, had a very similar provision as well. Here we go. Yep, there's paragraph 12. The validity, construction, and enforceability of this agreement shall be determined exclusively by the laws of the state of, there it says it's blank, but you would put Florida, right? You would write all of this out in your Word document, and you would write Florida, okay? So we check that, and whether you phrase it the way it's phrased in this contract or whether you phrase it the way it's phrased in this other sample contract, they both have the same effect, okay? You just pick one and you stick with it, okay? Or pick one phrasing and you stick with it. That's okay. The next fact would be clauses shall be severable. All right, well, let's see. Do we remember that terminology? Let's see. Here we go. In paragraph 14 of this sample contract, if any of the covenants or conditions of this agreement should be found to be unenforceable in a court of law, then this agreement is severable, and all remaining covenants and conditions shall be enforceable by said court. That's a severability clause. I talked about that in class last week. Severability clauses mean that if one clause of the contract is ever deemed unenforceable for any reason, the rest of the contract is still valid. And all contracts should include severability clauses, because without them, one bad clause could make the entire contract invalid, and you don't want that. So, and let's pretend we looked at this one first. Well, looky there. Severability of clauses. In each section of this agreement, shall stand independently and severably, and the invalidity of one section or portion thereof shall not affect the validity of any other portion. In the event any provision shall be construed to be invalid, no other provision of this agreement shall be affected thereby. Perfect. That's absolutely a valid severability clause. So whether you chose to include this language in your, by typing that language up, and you can type it up exactly in your Word document of your contract that you're writing, that's fine. Or you could choose to use this language from paragraph 14 of this sample contract. Pick one, pick the other. One is not more right or wrong. You just want to pick applicable language and stick with it, all right? And you would not combine them. You would just pick one or the other, all right? And that's fine. So checking off our facts as we go. We got severable, and then this last one, no modification may be made except in writing and executed by both parties. Well, we touched on that a little bit in one of our other prior paragraphs, but let's look at it again. Oh wait, modification. Here's another paragraph that talks about that. There may be no modification of any of the provisions of this agreement except in writing, executed with the same formalities as this instrument. Perfect. You could include that very clause right into your contract, okay? And like I said, even though you touched on it a little bit earlier, that's okay. You can repeat certain things. That's not a problem. As long as they're consistent and you're not contradicting yourself, that's okay, all right? So we can check all of those facts off. Perfect. And then what is our next and kind of last bit of facts here? Miss Applegate will not compete, including servicing or soliciting customers or divulging any business practices, including but not limited to manufacturing and marketing, with all-you-can-eat ice cream while employed by the partnership, as well as not obtain employment by a competitor of all-you-can-eat ice cream in the state of Florida for a period of 2 years following the end of her employment relationship. Okay, that seems like a lot, but let's see if any of these sample contracts have a similar provision, right? We don't want to compete. There's some type of restriction here. Let's see. Let's look at the paragraphs in this sample contract. Here we go. Employee agrees that here it says he, you're going to adjust it to she when you're writing, is not going to in any way, it appears, compete with or solicit customers, compete within a geographical area. You see all this language here? What you can do is effectively, I would say, look at paragraphs 8, 9, and 10. You don't need to include them exactly. Arguably, though, depending on the facts, you might be able to include them exactly. I'm going to leave that judgment call up to you. You just want to make it accurate based on the fact pattern I presented. And you could pretty much almost virtually adopt all of this language I gave you, or adopt some of this standard language into your contract and title it a non-compete provision, title it a restrictive covenant provision, or not title it at all and leave it in this kind of format similar to these 3 paragraphs, or some combination thereof. That's okay. You just want to make sure that it's accurate, properly tailored to your client or to the client that you're drafting the contract for, right? Here, the all-you-can-eat ice cream and Miss Applegate, and just make sure it's accurate, right? And if there's anything in here that I didn't put in the facts, you want to make sure you don't include it, okay? And so that is basically it, guys, in looking through all the facts and looking through the contracts in my sample. I can tell you that's basically it. So, and that's how you would do this. This is how you draft a contract, okay? And then what you would do is, though, want to make sure at the end you include this paragraph beginning in witness whereof the parties have hereunto executed this agreement in duplicate, each of which shall be deemed to be an original on the day and year first written above. You want to include that. That's kind of like your concluding paragraph, all right? And then you want to just add in your signature lines, okay? And it would just be by employer and employee. That's it, right? Because one of the partners will sign on behalf of the partnership. That's their authority as partners. Don't worry, this isn't a business organizations class. That's just how it works. So you wouldn't need a line for all the different partners of the partnership. This agreement is just between All You Can Eat Ice Cream, which as a legal entity of a partnership is hiring Miss Applegate as the business operations manager. And that's why you would just simply have these signature lines. You can include witnesses. There's no requirement under the law that an employment contract have witnesses, but it doesn't hurt for that to occur. So you can literally include this right as is. You would just copy it and include it right in your Word document, okay? So that is it, guys. That's what I mean when I give you a fact pattern and I give you samples and I want you to combine, basically use the information in the fact pattern, look at the samples, and figure out how to write the contract and the contract terms based on the fact pattern provided. So in essence, you are creating it from scratch, but it is very much and very well informed and oftentimes almost verbatim by contract provisions that are already in existence, because as I mentioned, there's no need to reinvent the wheel here. A lot of these conditions are common and should be included in contracts, okay? So that's it. If you guys still have any questions after watching these 3 recordings, please don't hesitate to reach out to me, okay? All right, good luck, and I will talk to you guys soon. Have a good day.